1st of October, and when there was seeming delay in releasing my client, I came back to this honorable court and got an order of court. This order was made ordering the SSS to produce my client to the court on the 23rd. On the 23rd of October. The order was served on the authority and it was disobeyed. Then on the 26th, I came back to this honorable court to say that the order that this court made on the 23rd has not been obeyed. That I brought another application for an order that this honorable court should make an order that my client should now be transferred from the facilities of the SSS to the prison where, practice-wise, conventionally, he belongs after arraignment. And the court made an order that the defendant should be transferred from the facilities of the DSS to the prison service, to the prison yard. That order was made on the 26th. We served them the order on the 26th. There's an acknowledgement of that order. That order was not obeyed. On the 28th, I brought an application, what we call Form 48, which is contempt proceedings against the authority, that they should show cause why they are in disobedience to court order. That contempt proceedings was served on the authority. Now, in addition to it, we came back to court. I filed a motion asking the court that the court will not give them opportunity of saying anything in this court until they obey the order. It is on the premises of that application that they came with a counter affidavit, and that was how we saw that they had gone to the Federal High Court to get an order. But there is a point to make. In all of this, the 3 orders we got from this court predates the order they got. All our orders were gotten between the 23rd and the 26th of October. But their own order was gotten on the 10th, ex parte. And an ex parte is supposed to last for 7 days, then you come back to court and then serve us. But what we're saying is that it is for the world to look at what is transpiring. We are asking that the rule of law should be obeyed. We are not saying that Nnamdi Kanu is declared, did not commit anything. But under Chapter 4 of our Constitution, he's presumed innocent. He's supposed to enjoy the bail that was given to him to enable him prepare for his trial. What we are saying is that whatever you have, put it in front of the court. Let us come and then follow it, sequentially, and then look at it from the point of law. But we are still at the preliminaries where somebody has been granted bail for over 1 month, and we're still arguing as to whether he will get his freedom or not.
So how do you react to the issue of the application made today for discontinuance?
The application made today for discontinuance, I will not comment on it anymore because the court has adjourned for ruling. And then if I go into the nitty-gritty of that fact, it will be short sub judice. And as a lawyer, I cannot be found wanting in this regard.